Good morning. Are you Crystal Latulus? Will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
Ms. Latulus, in cause number 25 DCCR 0850, you're charged with the second-degree felony offense of abandoning or endangering a child from May 30th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they charged you with? Then in cause number 25 DCCR 0851, you're also charged with the second-degree felony offense of abandoning or endangering a child from May 30th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for 5-year deferred probations. There would be $500 fines in each case, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or a denial of naturalization under federal law? State tender's number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Latulus is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. What is the current status with regard to contact with children?
I am.
You have them?
Yes, ma'am.
It wasn't a condition of your bond that you not have them?
The ones that I have, I don't know the other ones that I got shortly on. Colin and grandbaby.
What's the status of those two?
They not with me.
So what children do you have with you?
My other 4.
Was CPS involved?
Yes, ma'am. They closed it Friday.
They closed it Friday. What was their finding?
They
Stand up. Speak up.
they just closed it. I went through parents and I did everything I had to do.
You did go through parenting classes? Give me just a second. Did you take regular drug tests with them? Did you pass all of them, or do you have any issues?
No, ma'am.
You passed them all?
That's all.
So where do you and your, I'm printing that out, where do you and your children live now, the ones that you have?
We stay on Spencer Drive. No, ma'am. We stay here.
So where are these two?
That's one of them is my grandbaby. She with her mama, and my other son, he's with my grandma.
Okay, so it is still a condition of your bond until sentencing. I'll look at more information then, that you are not allowed to have these 2 children.
That's fine.
Okay. All right. So you need to stop on your way out today and talk to probation before you leave the courtroom. And she's sitting at that desk right over there. And then we'll see you back at sentencing.
Thank you, Judge.
Thank you, Your Honor.
Good morning. Are you Donnell Coleman? And Ms. Coleman was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
Not from the fence.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. I find that you're mentally competent and understand the nature and the consequences of that plea. Before I sentence you, I do want to find out, what is the status of the children? Are they still with dad? And do you have court orders on visitation and things like that, or what's?
No, ma'am, it was just a bond stipulation.
It was just the bond. So is CPS still involved, or is the case closed?
The case was closed back in March.
And so y'all don't have any formal papers with regard to custody or visitation or child support or anything like that?
No, ma'am, because with the bond stipulation, they had me do a 12-hour course, a 12-hour cancer course through CPS. And so I actually got the certificate and I showed.
Right, I've got that.
And after that, I know once I finished those classes, it was just the bond stipulation was that I just couldn't have contact with them until I got a disposition.
What's the plan? What have you, do you and the child's father get along? Have y'all talked about what's going to happen after today?
Yes, ma'am, we go for really well.
So, but what's the plan on where the kids are going to live and with you?
Yes, ma'am.
Ms. Malfino, any issues? I have the parent, it looks like CPS has done what they, my concern is that there aren't any formal, yeah, there's no formal court orders with regard to custody, visitation, things like that. And that's great. I hope y'all are getting along and you guys can make whatever agreements you want. But it's always better to have something legal if you're not together, so that if there's a disagreement, nobody's doing one thing or taking kids or not, or things like that. So my suggestion would be,
We really did communicate good, and I had never gotten any information where I had to deal with anything legal.
Well, it appears from his comments that they are on the same page.
mhm.
I'm happy to reach out.
Well, but he says he plans to share
Right.
Josiah. So I guess, I don't know if y'all, and then you've got also Kylie. So do you have Kylie, or Kylie's with dad still?
No, I have Kylie. It was just Josiah, which the stipulation was for because the case was with him.
Yeah.
Okay,
And I know the way we co-parent, we do share both kids. Like he comes get them periodically, and I have them as well. We just share both of them.
okay. All right, then I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. I am going to allow you to have contact with both of the children. You've gone through the parenting class, and so I don't think, I'm looking to make sure it's not on here. If you do everything that you're supposed to while you're on this probation, then this is an excellent opportunity. You have not been in trouble before. There's no reason to believe that you're not going to be successful. And if you successfully complete it, the case will be dismissed at the end. You'll never have a felony conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. So you're Ronnie Green? So Mr. Green has 2 motions to revoke his unadjudicated probation, and then there's a new offense that's been indicted. And Mr. Coleman, I had read that and was reminded once I read your motion and the request in your motion with regard to, there was some money that was found and that has been taken from that, the last arrest and indictment. And what Mr. Coleman is asking is that I order as a condition of Mr. Green's probation that he go to the safety facility for treatment and that he be ordered to pay, which I can do, that amount from that money, and the state would be willing to forfeit the forfeiture, for lack of a better word. Here's where I am. What I think the best way for me to handle this is to go through the motions, get pleas of true or not true to those motions. I do what I do on the motions. If I'm inclined to continue him on probation, and a condition of that becomes safety, then I would definitely entertain what that motion is, but without an updated pre-sentence report and more information about the allegations and how he pleads to them, and if we have to have a sentencing hearing and all those kinds of things, I think I need to do it in this order. So what I'd like to do is go through those motions today, and we can just reset it for sentencing without any agreement. Is that?
Well, this time, Judge, I can tell the court he'd have to plead not true. The basis of the new offense, probable cause search of the car, was a canine search. After reviewing the evidence, it's pretty clear to me that it is definitely a bad canine search. However, I cannot argue that merits of that until I do canine discovery. It's not common for the handler to turn over their handler records to the DA's office, so the DA's office does not have those records. So I did notify the state last week that that's what I thought after looking at the discoveries, that I would need to request that. So that's what I would need to do.
Sure.
Even for a motion
For a hearing on this, because those are the only
It's
allegations.
the only allegations of these new offenses.
So let's go through the motions. What I'll do is set that hearing out a little longer than normal to give you some time to get that information. And then if for some reason these allegations are untrue or can't be proved true, or the state has an issue as well once you guys get into this, then it would just be a matter of if there's other things going on with probation, through administrative hearings, through testimony of the probation officer, that would lend to any type of treatment. They're not alleged in these, so that wouldn't necessarily be a revocation, but that could be additional conditions based on other things that go into it, even if those cases, obviously the level of proof for me is different in a motion to revoke than it is in a trial. So let's at least get this done. That gets us with an updated pre-sentence report getting started. You guys can work on the canine issue, and then we'll come back and see where we are for a hearing. Okay? So, Mr. Green, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And will he waive the formal reading of both motions? Mr. Green, in cause number 23, DCCR 1502, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 18th of 2024 for the offense of possession of a prohibited weapon, and that was a 5-year deferred probation. Is that correct? These are the same two. I need the,
Which one?
I need 24 DCCR 1320.
Yes, ma'am.
Please. I can probably get to it, but give me just a second.
Watching it dry is way better than painting.
Agreed.
ऊंचाई का मौका है पूरा फिर भी ये पल
All right, in cause number 24, DCCR 1320, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 28th of 2024 for the offense of possession of marijuana, a third-degree felony, and that was a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 alleges in each case that you committed the new offense of money laundering between $2,500 and $30,000 on June 24th of 2025 in Jefferson County. And is that true or not true? Count 2 in each case alleges that you committed the offense of wrong, fictitious, altered, or obstructed license plate March 3rd of 2025. And is that true or not true? All right, then I'm going to have enter pleas of not true to counts 1 and 2 in each of those cases for you. We will reset the case for a sentencing hearing. I'll get probation to do an updated report. We'll set aside some time for these. Mr. Coleman, looks like these are two separate alleged offenses, and so I would guess you would have a couple of different
It's
officers.
the same transaction.
Well, they've got different office dates. Yeah.
I've got a March 3rd for the fictitious license plate thing, and then a June 24th.
I'll double check the dates.
No, they don't have to be with the money. You don't have to do the same.
Yeah, it's the
I'll
same
double
day.
check the dates and I'll amend if necessary.
Well, or just you can do a motion to modify the date.
It should be the same. It's the
Okay.
same transaction.
All right.
Okay, so then it shouldn't be, well, maybe an hour on a regular docket day?
Yes, sir.
And we'll see where we are at that time. Now, obviously, at that time, if you anticipate there being more evidence than an hour with regard to the search and all of that, let me know, and we can set it for a different date. But at this point, we'll put it just on a regular docket date, but at 11.
It probably would be fine for now.
Okay, all right.
I think the real question is, how long does it take the handler to retrieve the records and get it to the state? That's going to.
Right, I know that's taken some time, and if there's anything that you need me to do to help out with that, just let me know. Okay, thanks, you're free to go.
Thank you, Judge.
Unagreed.
I need
Hey.
to.
Because it looks like the magistrate was Judge Collins, and he set a bond at $75,000. Do you have a GPS monitoring device on?
And Judge, of course, he's had this monitor on the entire time for the past 8 months, and we haven't had any issues or anything since he has been out on bond.
I'm just trying to figure out why it went from 75 to 7. An error.
I mean, I haven't seen anything that leads me to think any other thing.
Yeah.
Because it wasn't changed. On 4/11 is when it was put in the bond screen as 7,000.
Okay.
You know, so I feel like.
The bond is 75,000, which means Mr., and I'm not going to, I appreciate that he's done, I guess, well, as far as we know. I haven't
I'm still looking.
received anything, but the bond was set by Judge Collins at 75,000, which he took into consideration, obviously, the same things that I'm taking into consideration. There is no way that a $7,000 bond with these types of allegations, in my opinion, meet the criteria of 17.15 and all of those criteria with safety to the community and the complaining witness and criminal history and all of those things that now I know about. So that bond is going to be enforced. It is $75,000. It means you will go with the bailiff today. You're going to have to make the $75,000 bond. The same conditions that Judge Collins put on that bond still apply, which is to remain in Jefferson County, to have no contact with the complaining witness, and to wear the GPS monitoring device at all times. And then let's go through. You want to go forward with a trial in your case still, correct? And so we'll do that. And Mr. Anders, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis will remain on your case, and he will begin preparation for trial. You can go back with the bailiff.
And there it is, another day in court, where every decision carries weight, and every word echoes far beyond these walls. Today, Ms. Latulus faced her choices, confronted her past, and stepped into the uncertain path of probation. Justice is not always about punishment. It's about understanding, accountability, and the chance to make things right. These children, these families, they are the quiet heartbeat behind every case. And as the gavel falls, we are reminded, our actions define us, and every second in this courtroom can change lives forever. What would you do if it were your choice?